Been advised overnight that this morning at ICAC a thank you note from me in relation to the bottle of wine will be presented. I can't explain.
Let me just ask you this, because one of your predecessors in your job said that the issue at the moment is that it's only the tip of the iceberg in terms of lobbying and influence peddling that is actually properly...
By 2014, the New South Wales Coalition Government was considering how to best amalgamate New South Wales councils. This was in response to intense lobbying by the property industry in general and the Property Council of New South Wales in particular.
But if politicians play with negative gearing, all this will be at risk. Property is no game.
The government now viewed councils as a blockage in the development pipeline. To the industry, they were a hindrance to profits. Some councils subsequently engaged independent consultants to measure and advise. Within the proposed Northern Beaches Council area, consultancy KPMG delivered its independent review of structural options for Manly Council and Pittwater Council on the 1st of April 2015 at a cost to ratepayers of around $200,000. According to KPMG, both councils met government-imposed financial viability criteria. Pittwater and Manly were already fit for the future, and this outcome, repeated elsewhere many times, surprised the government. Then, on the 5th of June 2015, the supposedly independent government tribunal, IPART, issued new Fit for the Future assessment criteria. There was now a scale and capacity hurdle which could only be met with large populations. Smaller councils, such as Pittwater, now failed automatically. All councils were required to submit proposals to the government by the 30th of June, demonstrating how they now intended to become fit for the future, including by merging with nearby councils if necessary. Subsequent Freedom of Information requests by Fairfax Media show that by June 2015, the government had also engaged KPMG to conduct a statewide analysis of the supposed financial benefits of council amalgamation. It seems the KPMG then took the Pittwater and Manly Council report, for which they'd already been well paid, and reworked it into the model for council amalgamation statewide. KPMG then charged the government a further $400,000 for what was in effect the same analysis repeated a number of times. The portion of that August 2015 report the government did release, a list of data sources used by KPMG, undercounted the cost of laying off council workers by half. A noted academic also took issue with the report, describing it as being awash with errors. A month later, the government released an IPART-sponsored report by Ernst & Young, which said that the idea that council mergers would save money was, quote, not provided strong support by economic analysis. Whoops. By January 2016, there were 35 merger proposals designed to rationalise local government areas either by amalgamating councils or by redrawing their boundaries. Delegates were appointed to assess the proposals, and councils once again had to provide submissions to the relevant delegate. In scenes reminiscent of Utopia and Fawlty Towers, Greens MLC David Shoebridge was requesting, under Freedom of Information law, copies of all KPMG analysis and modelling
to the Office of Local Government, Minister for Local Government and Department of Local Government, requesting all of the KPMG modelling analysis for every proposed council amalgamation proposal.
What, do you want to grab a pen? Yep. To these ones, you simply reply, we reject this application on the following grounds. Firstly, the number of documents requested is far too voluminous. Secondly...
You stopped writing?
Yeah, it's just... Secondly, sourcing said documents would constitute an unreasonable burden on the office in terms of time and resources.
The department released just 3 pieces of analysis.
Am I missing something?
Oh, clearly.
We then received a response from Minister Toole's office, which went along the lines of, oh, thank you for your request. All of the financial modelling is already available on the website. And that the only documents that have been withheld, according to Minister Toole, are an October 2015 business case and a December 2015 merger impact analysis. They are both, we're told, stabbed cabinet in confidence, never to be released. Just a few days later, though, we received the third and final response from the Department of Premier and Cabinet. And that response actually shed some light on what's happened. Because it turns out there's more than just the business case and merger impact report hidden. The Premier's office has another 22 secret reports, hidden from councils, hidden from residents and stamped never to be released.
Submissions for the Greater Pittwater proposal were made to Delegate Mr Richard Pearson on the 2nd of February 2016 at the Mona Vale Golf Club. This dissipated much of Pittwater's energy, quite possibly by design. A second round of submissions for a Northern Beaches Mega Council took place on the 21st of March. The delegates' final report was published on the 20th of April, 4 full weeks after residents had made their final pitch. On page 13, Delegate Pearson says that as this merger proposal was put forward by Warringah Council rather than the Minister for Local Government, it did not have the benefit of financial advice or modelling from KPMG, as did all the other merger proposals put forward by the Minister. I consequently commissioned financial advice from KPMG, which I have relied on for my consideration of the financial benefits of this merger proposal. By this time, KPMG must have been laughing all the way to the bank. Less humorously, for those who'd spoken in defence of Pittwater, the new report, critical to informing Pearson's final recommendations, had not been available to them. If so, this may be a matter for the ICAC. Had the report been available, most people would have quickly worked out that the claimed $111 million benefit from amalgamation into the Northern Beaches Council amounted to less than 6 cents per resident per day, 10 weeks for a cup of coffee, assuming all goes well, for 20 years. On the 12th of May 2016, 19 new councils were proclaimed. Previously foreshadowed amalgamations that had proven especially controversial, and those involving councils that had initiated legal proceedings, were not included in the proclamation.
We want our councils back! We want our councils back! We want our councils back!
But Pittwater, which had voted to take legal action to defend itself, failed to do so following a last-minute coup by the Mayor and General Manager, who saw their opportunity during the absence of 2 defending councillors. In May 2017, another Freedom of Information request by Shadow Local Government Minister Peter Primrose, seeking a list of people that KPMG had interviewed for its report, came back with 3 pages redacted. According to Primrose, if the Minister and Department genuinely do not hold a copy of this pivotal report, then their actions throughout have frankly been a mockery. How is it that they can have legitimately fulfilled their responsibilities? Or have they acted recklessly? On the 3rd of May 2017, a member of the public, Pittwater resident Philip Walker, made his own Freedom of Information request for the KPMG analysis and modelling. Walker's request was identical to that made by David Shoebridge. Walker had noted that Shoebridge, when his request failed, did not take advantage of the review process offered by the 2009 Government Information and Public Access Act. These requests are commonly known as GIPPers, and Walker intended to avail himself of the process. A GIPPer response can be reviewed internally by the department involved, but this path invariably resolves in the department's favour. It can also be reviewed by the Information Commissioner, but there's a third option, an external review by the New South Wales Civil and Administrative Tribunal, or NCAT. This is a formal process resulting in a court hearing when necessary. Walker had learned the mechanics of this through years of trying to extract information from Pittwater Council about the Crown Land Reserve at Beebe Park at Mona Vale. On the 17th of July 2017, Walker filed an application seeking an NCAT review of the Department of Premier and Cabinet's decision to refuse all documents. During the review process, the department released 23 of the 25 Cabinet and confidence documents listed for David Shoebridge as documents that he could not have. Walker received records 1 to 20 and 23 to 25. Records 21 and 22, which contained the business case, were resolutely refused. Though Walker appears to be succeeding where others have failed, these documents are August 2015 merger proposals that are mainly in presentation form. They're summaries only that for the most part do not show how decisions were arrived at, but there are exceptions. On page 25 of Record 25, a document plastered all over with Cabinet in confidence and not for circulation, we find confirmation that the Council Commissioned independent review of structural options for Manly Council and Pittwater Council did indeed become the model for council amalgamations statewide, quote, "In regard to testing model results, we will first conduct merger analysis on the Northern Beaches cluster, given KPMG's familiarity with the region and ability to draw on our previous work to provide a sense test and a point of reference for the model results," unquote. Pittwater and Manly ratepayers actually paid for the privilege of suffering their own demise. Upon further review, all of which required case conferences in court, Walker received an additional 27 Cabinet in confidence documents for a total of 50. By this stage, the legal issues were becoming complex. Witnesses called by the Crown would be subject to cross-examination by Walker, and Walker also wanted to subpoena key figures from the department. Evidence had to be introduced and tested. Abstract concepts such as scope and waiver needed broad discussion, and that would require not only a precise knowledge of court procedures, but detailed case authorities as references. The NCAT suggested that Walker seek legal assistance. This would obviously require major financial resources, unless...
Now, Phil, what I've got is the submissions that you actually need to sign, and a copy of the affidavit that I've done, and you've also got the original back of the Information Commissioner's report that she did.
Oh, right, now.
You wanted a copy of that.
Oh, so this is from...
At the end. They're your documents. Yeah. Submissions and the affidavit. So I've got 7 copies there, and I've got the originals. And the original affidavit's been sworn by me. It's by in front of a JP, the whole thing. And the submissions, as you know, are yours. They're the ones that we've worked out together, and you sign that before you file it.
Yep.
But that's what we've got.
Now we've also got the summons.
I've got the summons, and we need to go through the summons because we need to get somebody there from the department who actually knows something about what actually happened in this task force. As you know, in the cases that have gone before, and indeed in your case, you've got Karen Smith saying, "I spoke to Clark and another person called Smith, and they've given me all this information," and they've redacted part of that, so they're not revealing part of it. But what we say is that to have any credibility, they've got to have somebody there who actually knew what was going on, and they haven't done that in any of the cases, and in my view quite deliberately haven't done it because they don't want that person to be cross-examined.
You were talking about getting best evidence.
Yeah,
best evidence available. And here's the plate.
Yeah. And I think you've identified in discussions with me that the person you think that probably best suits that is a fellow called Clark, because he was in the task force and he's the one that Karen Smith says I spoke to and got the information from. Well, you want, and the community wants, and in the public interest, we want the people there who actually knew what was going on. We want them there so that they can answer questions about what documents there are, especially the underlying documents, which have never been disclosed. The underlying documents to the KPMG reports have never been disclosed, and they haven't been disclosed in any of the applications that have been made to date, except for 2 documents. You know, when we get to see those, and I hope we do, including the business case, they'll probably just be full of the final figures too. And what you're seeking in the application is not only those reports, but the actual workings of KPMG, so that the public can see just what was going on behind the scenes, what fiddling with the figures were taking place in order to get to these final figures. And that's what you've been after ever since you spoke to me about your application. You know, how can we get for the public, how can we test these reports and final figures? We've never been allowed to do it. We should be. Baston, in the case of Ku-ring-gai, for example, made it very clear that the government should and must release these documents on basis of common fairness and public interest, and they never have. They've hidden them. So what you're doing is very significant in my view, because what you're doing is seeking in the public interest to get basic material that KPMG did with its modelling and so forth, and expose that to the light of day. And then the public can see whether this $2 billion that they've been promised from this is just all a big smokescreen. Because we know it is, you know it is, but they tried to hoodwink the public over it. So I mean, I think what you're doing is very significant, and I think that that's certainly why I'm helping in the public interest. And when you asked me to help, I was very pleased to do it, because I was one of the people affected by this. I know you guys up in Pittwater were devastated by the fact of what happened to you, devastated by it, because you lost your council, a very good council, due to all this shenanigans and faulty process, and were never allowed by the then mayor and by your local member really to actually be able to argue your day in court. You were denied it, while others like Hunters Hill and Woollahra and others did go to court and they won. They won, but no one's got these documents yet.